Provincial governments speaking out about federal immigration policy, federal cuts to staffing numbers, federal court case law on the adequacy of counsel and the importance of language testing on this edition of Impulse.
Hi, I'm Howard Greenberg.
Hi, I'm Greenberg Hameed.
Well, today, Naman, we have some interesting topics. One of the topics which is of most interest to me today is the reduction in the civil service of 60,000 workers. This is quite astounding. The Prime Minister is actually pointing to various departments, and one of the notable ones is immigration.
Right.
So with all the staff cutting that's already occurred and the delays in processing applications, now they're suggesting there's going to be another significant round of cuts, which can only mean one thing: more AI and more automated processes. If you don't have people and you have applications, the only way to do it is through technology.
Well, and that raises a lot of concerns because we've seen so far that decisions using or leveraging AI have been questionable. And this is a second round of cuts. We know that earlier we reported there were a reduction of about 3,000 immigration officers.
Right.
So how are they going to manage? There's still an insatiable appetite for Canadian immigration, both in Canada, people who want to stay, those who are looking to come in, study permit, work permit refusals are high. How is this going to play out with a further reduction?
Well, there are further repercussions. Bad decisions equal federal court applications to rectify those decisions. And the backlog in the federal court's horrendous. It takes years to get your application properly heard in the courts. So what's the solution to this?
Well, look, I think we'll talk about it when we get into case law, but you have to have very capable and precise counsel, and you need to be reviewing your refusal letters if you face a refusal or a procedural fairness letter, because there are gaps in the system right now, and you have to advocate strongly to get through.
Before we go to the case law, let's just spend a moment and talk about who's been invited under the express entry system. And it looks like medical personnel are the flavor of the week.
Right. There was a draw for healthcare professionals.
Right.
Roughly 4,000 people were invited.
Right.
So although there's a lot of concern about eligibility for PR, there are segments. We've talked about francophones, healthcare. We've seen trades. There are pockets that are opening. So if you're in those occupations, you should be aware and get an express entry profile in early.
And your strategy as to how you structure it is critical to success.
Right. Well, you're talking about what was on your mind. There was a lot of news last week from premiers speaking out about immigration. We see that Doug Ford took a strong view that he felt that federal immigration on work permits was not effective provincially. These were with respect to asylum seekers who he felt are in the province, capable of working, but waiting too long. He may have stepped a little bit across some jurisdictional grounds by suggesting that Ontario should issue work permits. But I think he's expressing some frustration that the federal approach is not making sense in terms of provincial needs here in Ontario.
Well, I for one, happen to agree with him 100%. I think the provinces and then down to municipalities should have a leading role in work permits and ultimately in immigration. You got to be at the ground level to understand what's going on with an economy changing as rapidly as ours.
Right. And we see Alberta has spoken out too. They're concerned that the federal emphasis of opening up the invitation for parents and grandparents, given that there's health infrastructure challenges in Canada, doesn't make sense. So you can see provincially there's a stronger voice. Many of the provinces have lost 50% of their spots. But I think one of our points is being better, smarter selection, both provincially, federally, and having some consolidated thinking on both sides.
So let's drill down to the case law now. Any cases that attract your...
Yeah, there's one that caught my attention. Look, we get approached by clients quite regularly, and unfortunately, in many instances, the representation in their application, whether it's a work permit, study permit, PR application, is lacking. And the federal court has looked at a particular scenario worth reading, the Bailey case, where the inadequacy of counsel, in this case, failure to put in critical material medical reports in an H&C application, was deemed to have violated the right of that individual to a fair process. And they overturned the decision, and it's being sent to a new officer. And from my perspective, pick your counsel, your representative carefully. Once you make an application, dealing with a refusal is going to be challenging. But if you do have a refusal and you feel like your representation was lacking, there can be recourse, and a judge can look at your case and potentially give you another opportunity where it was material and there was a lack of precision from your representative.
Whether you're represented by a consultant or
Correct.
a lawyer.
Either one.
Either one.
Mhm.
Okay. Any other pearls of wisdom from your review?
There's a lot of applications through the temporary foreign worker program for LMIA.
Right.
And when that approval is issued, it's based on the terms of the offer for the position. When you file the application for the work permit, the attention is on the worker. And we see two cases where the concerns were around the proof of language. In one case, the federal court overturned the decision because they felt the officer was not reasonable in turning their mind to the evidence. In that case, there was language testing. There was other evidence of how they worked in the English language. And it was well explained. The officer didn't engage. It was overturned. In another case, there was simply transcripts and some evidence of how English was used, but it wasn't particularly detailed. The officer fully engaged on the issue, refused it. The federal court said it was reasonable. So when you're filing an application, you have to make sure that you explain the relevance of how your language relates to your job. So I think, again, being careful in how you represent, it's a hot topic. There's a lot of refusals on the issue of language, whether it's work permits or study permits, but there's a higher level of obligation to articulate that in your application.
Well, at a higher level, there's a lot of refusals on applications in which they're just deficient.
Right.
They don't have enough information in them. And you have to anticipate what the officer is going to want to see when you start looking at financial information behind bank statements, behind proof of funds for education, for a study permit. All of these areas, the applicant's susceptible to not providing a complete application. And the courts are very much in favor of officers who say it's deficient.
Especially now going into an environment where there'll be more AI,
Right.
less officers, faster decisions with less, human interaction. So I think getting all of that information in properly is critical.
Well, I think that covers this week.
Yes. Thank you very much for joining.
Thank you very much for joining us for this presentation. If you have any questions, please do not hesitate to reach out. Thank you. On my mind is the reduction in the civil servants service. On my mind is the reduction in the civil servants. On my
Suffering succotash, Howard. Some difficulty getting
on my
those words
mind.
out.
I'm sorry for that, viewers.
Okay, let's do this. The energy up.